Oh yay, oh yay, oh yay, the Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning. I'm sure everybody had a lovely drive-in in the Knoxville Tuesday rain traffic. Call the first case, please.
Fred Hayward versus Chattanooga-Hamilton County Hospital Authority et al.
We'll hear from the appellant.
Thank you, Your Honor. Your Honor, if I may, or Your Honors, if I may reserve 5 minutes for rebuttal.
That'll be fine.
My name is Michael Thomas with the Chattanooga Bar, and I'm here on behalf of the appellant Fred Hayward, who is the plaintiff in the trial action. Before Your Honors is a case involving a substantial compliance issue with a HIPAA release pursuant to 2926-121. Given the number of times this matter has come up before the Court of Appeals over the years, I'm not going to spend too much on the background of both 121 and sort of the law that applies to it. Instead, I'd prefer to jump right in with Your Honor's permission. These matters are determined in accordance with the Martin case the Supreme Court came out with, released in 2020. In there, they state that if a plaintiff's noncompliance neither frustrates or interferes with the purposes of Section 121, nor prevents a defendant from receiving a benefit the statute confers, then a court is more likely to determine that the plaintiff has substantially complied. Here, as was attached to the plaintiff's motion to dismiss, as at Exhibit 2, were 5 HIPAA releases that are in question. In there was an issue with the purpose section as found by the trial judge. While I'm not conceding at this point that it's defective on those grounds, I will argue as if the court will determine that to be found defective. And here the plaintiff asserts that the only records related to the treatment came from Erlanger. Now, I've jumped from the releases directly to the records because the plaintiff is going to rely on Wentzler v. U, to unpublished 2012 case, which I believe Your Honor was a part of back in the day. Although you didn't write it, you had joined in with the opinion. And that case found that there was 2 HIPAA releases sent to both the doctor and the dentistry office practice that they worked with. There was a defective HIPAA release as to the doctor, and it was ultimately found that the dentistry practice had all the records in question. And so even though they found a defective HIPAA release, they found that there was no prejudice found as to the dentistry practice on the grounds that they had the ability to review all the medical records involved in the treatment of the patient in that case, such that they were not prejudiced by a defective HIPAA release. And that is what the plaintiff is asserting here. Here we're asserting that if it's ultimately found that the releases are defective, that Erlanger wouldn't be prejudiced on the ground that Erlanger possessed all the medical records in question. Now, forgive me for using the word I, but I've always found this argument to be interesting in that the Supreme Court has found that this is a Rule 12 analysis, even though we're applying more of a Rule 56 analysis in the sense that we're bringing in outside documents to review whether substantial compliance has been met. And as you know, we have the HIPAA releases, we have the medical records, which have been brought up at the trial level, although they were not attached to the complaint, and they were not made, other than the releases, were not made a exhibit to the motion to dismiss. However, the plaintiff did assert that it did send HIPAA releases to Erlanger, UT Urology, which ended up being a department of Erlanger. So you'll see references to UT Urology, and the defendant has conceded that they are effectively one and the same. They are just a department of Erlanger. And they were also sent to Dr. Shridharani. Your Honors, the only records that were received on behalf of those requests came from Erlanger through SCIOX, their centralized medical record system. This provides solid evidence, I believe, that they had access to all these records. And it's
Counsel,
also,
let me ask you a question about that. Your client received subsequent treatment at the Cleveland Clinic.
Yes, Your Honor.
Would those records not perhaps be relevant?
No, Your Honor. I believe the 121 notices need only be sent to the doctors who will be potential defendants to the case.
No, I'm talking about, I'm not sending the Cleveland Clinic a notice, but was there, you're saying Erlanger already had all the records.
Correct, Your Honor.
But they didn't have Cleveland Clinic's records.
Cleveland Clinic's records were not substantive to the treatment and facts of the case, Your Honor. They were not named a potential defendant, and in no case were they ever intended to be a defendant.
I understand that they weren't intended to be a defendant, but mightn't Erlanger want to see the records for the subsequent treatment?
And I think that would be available later on, Your Honor, in discovery if they sought additional records that might affect the ultimate determination.
I'm not sure. I think we're talking a little bit of cross purposes here. Purpose of the authorization is so a defendant such as Erlanger can get all the records that might be relevant.
Yes, Your Honor.
Basically, so they can make an early decision as to what to do as far as settling or whatnot. My question to you, though, is could they get, with the authorization, they couldn't get Cleveland Clinic's records, could they?
No, Your Honor, they could not have.
Well, okay, so how can you say that Erlanger had all records that might be relevant?
Your Honor,
when these records there were definitely involved his subsequent treatment as follow-up for what happened at Erlanger.
Yes, Your Honor. I believe the 121 notice, however, only goes out to the potential defendants, and maybe I'm reading the statute wrong or interpreting it wrong, but I believe I recall that the 121 notice only goes out to potential defendants. I do not recall anything where it says that all treatment, even if it will not be directly involved in the plaintiff's suit, need be provided to each of the parties. I believe that's where...
Okay, so you're saying it's your position, and you may be right, that 121 just provides that potential defendants can obtain all the records from each other, but all that it pertains to is potential defendants?
Yes, Your Honor. I believe that's my interpretation of 121.
Is there any concern about the fact that the disclosure, that the release provides to disclose rather than to obtain?
Your Honor, I've had a hard time kind of following that argument, because if you take a look at all 5 releases that were attached as Exhibit 2, the response to motion to dismiss, you'll see that one of them says that it's UT and Shridharani to Michael Thomas. The second one is UT Urology and Shridharani to Erlanger. The third one is UT Urology and Shridharani to each other. The fourth one is Erlanger to Thomas and Thomas. And the fifth one is UT Urology to Urology and Shridharani. I don't really understand that argument, other than if you take a look at their motion to dismiss in the vacuum of the sole release that they attach to it, then I believe you can say, and I don't recall which one it was either Erlanger shall disclose to UT Urology, Shridharani, and Dr. Waldorf. I'm leaving Dr. Waldorf out for this purpose because he ended up not being a defendant, but he was important as that he was a treating physician at one point immediately after the surgery. But I don't really know where that argument comes from unless you solely look at the release, one release in that vacuum, which is also worth noting that The other releases also said UT Urology, Schroederani, and Waldorf to each other, and UT Urology is Erlanger. So they had access to it. So I don't know if it's a straw man argument or if they're looking at it just in the microscope of one release. I can't really follow that argument, Your Honor. I apologize.
So it's not necessary to interpret the letter that was attached?
Well, that's an interesting thing you bring up, Your Honor. I believe the case law says that as much as I would like for the letter to be interpreted as to 121 and substantial compliance, I believe the law is clear that the letter does not apply to the interpretation of the HIPAA releases, and that the HIPAA releases stand alone. I think the letter is there as more of a formality, as was found under Martin, not specifically the letter, but to get that 120-day extension of the statute of limitations and provide the notice required. But the HIPAA releases, I believe, are the substantive part of 121 in determining each other and how they are permitted to share those records, Your Honor.
Do you have any, was there not a case that basically involved that issue?
Yes, Your Honor, there was. I don't recall it, but and I apologize, we've gone over.
Go ahead, go ahead.
It says that you don't look at the letter. You solely look at the HIPAA releases for purposes of substantial compliance.
I recall I was arguing your position, and I was unsuccessful.
And that was probably the case I'm referring to, Your Honor.
All right, thank you. You have your time for rebuttal.
Thank you.
We'll hear from the appellee.
Your Honors, may it please the Court, Drew Reynolds here on behalf of the defendant, appellee, Chattanooga-Hamilton County Hospital Authority. Just want to start out by addressing a couple of things that were referenced during plaintiff appellant's argument. To the extent that Your Honors would consider viewing the pre-suit notices as going outside the record, the only reason that we would be forced to go outside the record in this case is because plaintiff appellant failed to comply with 2926-121A4, which requires plaintiffs to provide proof of service of the pre-suit notice, affidavits of mailing, that sort of thing, and 2926-121B, which requires that all that documentation be filed with the complaint. And so really, if that's treated as going outside the record, then I would submit that we've got a policy issue and that plaintiffs would never comply with the requirements of 121A4 or 121B because they would prefer to have the case disposed of by way of a motion for summary judgment as opposed to a motion to dismiss. And that's, the motion to dismiss format is what the Supreme Court has told us is the proper vehicle for challenging compliance with these HCLA requirements. And by HCLA, I mean Healthcare Liability Act. So from the defense perspective, the appellee perspective, there are three main issues in this case. One, whether the trial court properly granted the motion to dismiss. On that issue, it's worth noting the burden shifting approach adopted by the Supreme Court in Martin v. Rolling Hills Hospital. The plaintiff in a healthcare liability action bears the initial burden of establishing compliance with Tennessee Code annotated 2926-121 by stating in the pleadings whether he or she has complied with 121 and also by providing that documentation. So that wasn't done in this case. In any event, to challenge a plaintiff's compliance with Section 121, the defense is required to file a motion to dismiss pursuant to Rule 12.026 of the Rules of Civil Procedure and describe how the plaintiff failed to comply with Section 121 by referencing specific errors and omissions and whether the defendant was prejudiced by the plaintiff's noncompliance. Now, under Martin, if the defendant files a motion that satisfies this prima facie showing, then the burden goes back to the plaintiff, and the plaintiff has to show substantial compliance with 121, including demonstrating that the noncompliance did not prejudice the defense. We respectfully submit that we met our burden, the burden shifted back to the plaintiff, and the plaintiff did not meet his burden in this case. With respect to the prejudice issue, Martin notes that one means of satisfying the burden is by alleging that the plaintiff, the medical authorization provided by the plaintiff lacks one or more of the 6 core elements required by federal law for HIPAA compliance. That's because without a HIPAA-compliant medical authorization, a defendant would ordinarily be deprived of a benefit Section 121 confers, which is the ability to review medical records on the front end and determine if there is a case or not. It's undisputed this is a Healthcare Liability Act, and it was subject to the requirements, including pre-suit notice. However, the plaintiff in this case failed to comply with the healthcare liability requirements, specifically Section 121A2E, and that's the requirement that there be a HIPAA-compliant medical authorization provided with the pre-suit notice. The HIPAA release in this case failed to comply in 2 different ways. First is that the purpose section of the authorization is inconsistent with the statutory purpose. In other words, the authorization that the plaintiff provided in this case stated that the purpose was to provide his attorney access to the records. Now, because the release or use of protected health information has to be consistent with a disclosure, no healthcare provider could use these authorizations to get records. The purpose would have been inconsistent with the use. And second, as Judge Golden pointed out earlier, the authorization allowed Erlanger to disclose medical records to UT Erlanger Urology, Anand Shridharani, and Ben Waldorf, but not to obtain records from them as required by Section 121A2E. And that disclose versus obtain issue is controlled by, to my knowledge, Parks v. Walker, which is a case we cited in our brief involving a similar situation and authorization. The Parks Court held that the authorization in question was not sufficient to enable defendants to obtain the plaintiff's medical records. And, it may seem like we're splitting hairs, but, the trial court's observation in Parks is specifically what we're dealing with here, which is the release only allows a doctor to release, use, or disclose medical records. Thus, if Dr. Walker, in that case, Erlanger in this case, sends this form to another provider and asks that provider to send the plaintiff's medical records, the form simply does not provide authorization for them to do so. And,
Counsel, excuse me for interrupting. What about your opponent's argument that under the Winsler versus U case, there has to be a showing of prejudice, and he says we should have been given an opportunity to conduct discovery to show that you all had all the records you needed?
Well, there's a couple of issues with that. First is that plaintiffs are not typically provided discovery in response to motions to dismiss. And the second issue with that is that our contention is that there's no possible benefit to allowing the plaintiff to conduct discovery in this case, because nothing the plaintiff could have found in discovery would have filled in the missing information in the medical authorizations. Now, that doesn't specifically answer the question of getting into discovery to determine which, if a defendant got records from this defendant. But I mean, again, I think this is a situation similar to the Reese v. Waters of Clinton case that we cited in our brief, where basically the court found nothing the plaintiff could have found in discovery would have filled in the missing information in the HIPAA authorization. We would submit it's the same here. Nothing's going to change that HIPAA authorization, the defect there. And then because of the posture of this motion, the plaintiff is not entitled to conduct discovery to respond to a motion to dismiss.
Well, but doesn't the question of whether or not there's any prejudice arise only if the HIPAA authorization is not compliant, or it's not HIPAA compliant?
I'm sorry, Your Honor, could you repeat that?
Does the issue of whether or not the defendant, the medical provider, suffered any prejudice, doesn't that come into play only when the authorization is not HIPAA compliant?
That's correct, sir.
So by definition, you're talking about, so why couldn't this discovery have shown that Erlanger had all the records? I don't know if it would or not, but if that's what they were looking for, would that not be relevant to whether or not Erlanger suffered any prejudice from this non-HIPAA compliant authorization?
Well, I believe this is a somewhat technical argument, Your Honor, but, the best...
We love technical arguments.
I know the Court of Appeals loves technical arguments, and particularly ones involving Section 121. Your Honor, I think our position on that is that, could you repeat your question, please?
Sure.
I'm sorry, I've lost myself.
As I understand it, the discovery they were wanting was at least arguably relevant to whether or not Erlanger already had all the records, so Erlanger was not prejudiced by a non-HIPAA compliant authorization.
That's right, Your Honor, and under the paradigm of Martin, what we would submit we've done is we have shown that there is prejudice to Erlanger by virtue of the non-compliant HIPAA authorization. So we shifted that burden back to the plaintiff, and the plaintiff was not able to show that there wasn't any non-compliance. The plaintiff also wasn't able to show that there wasn't any extraordinary cause.
Well, but wasn't the purpose, at least stated purpose of the discovery, which you objected to, was to find out whether or not Erlanger had all the records?
That is the purported purpose of the discovery, Your Honor.
So your argument is they can't prove that Erlanger has all the records, and we object to any discovery they want to take to see whether or not Erlanger has all the records.
That is our argument, Your Honor.
Okay, they can't prove it, and we object. Okay.
Yes, under the paradigm of Martin, we submit that that's what we've done. We have shifted the burden to the plaintiff, and the plaintiff has not been able to show. There's no showing in the record that Erlanger wasn't prejudiced.
Okay.
And the basis for that is that you're saying that this is because it's a motion to dismiss, and it has to be based on the pleadings that have been filed with the complaint?
Yes, Your Honor.
Is that the underpinning of that argument?
That's the underpinning, as well as, generally speaking, plaintiffs are not entitled to conduct discovery in order to respond to motions filed under Rule 12. And again, it's not our choice to file those motions. That's what the Tennessee Supreme Court has said in Martin for defense to do. And then again, I think under the Reese v. Waters of Clinton case we've cited in our brief, we argue that there's no way that discovery, anything that's turned over in discovery can fix that deficiency in the HIPAA authorization.
Well, but it's not to fix the deficiency, as I understand it. What they're arguing is that it relates to whether or not there's prejudice. It doesn't fix the deficiency.
And so I would go back, Your Honor, to plaintiffs are generally speaking not entitled to conduct discovery in order to respond to Rule 12 motions.
Is this Rule 12, and I understand what the Supreme Court said about it, that's a Rule 12 motion, but does it not also provide in a healthcare liability action for a little bit more than a normal Rule 12 motion to dismiss?
Well, Your Honor, it's an interesting hybrid creature, I think, that we have created here, where as I just pointed out, I think there's some difficulty in treating it as a motion to dismiss or converting it into a motion for summary judgment. Sometimes I've seen, I'm sure Your Honors have handled cases where a material is inserted in that is not part of the record, and so it is viewed as a motion for summary judgment. And I believe there is actually a case out there saying that the reason that plaintiffs are not generally entitled to discovery in these HCLA healthcare liability cases is because because of the motion to dismiss format. However, if it were converted into a motion for summary judgment, then that argument goes out the window. The one thing I would say is that if we treat, as I said earlier, if we treat a plaintiff not complying with the requirements of the statute by failing to attach this documentation to the complaint, if we treat that as going outside the record, then it creates a bizarre incentive for plaintiff's counsel to not file that, because as far as I know, there's a dearth of case law addressing the failure to attach documents. I don't think the failure to attach documents to the complaint is seen as something that a plaintiff cannot cure, but, again, the incentive would be for plaintiffs to not file that so that every motion to dismiss were converted into a motion for summary judgment. They would argue that they're entitled to discovery. That's not the process the Supreme Court, however, has laid out in Martin.
Sounds like under the facts of this case that might be called a catch-22.
How so, Your Honor?
Well, that he can't, you've shifted the burden, but he wants discovery in order to prove, to shift it back.
Right. It is somewhat of a catch-22. It's a technical argument. But that's where we stand. That's our position. I would also note, just for the record, that the trial court, as far as the defense is concerned, properly denied the plaintiff appellant's amended motion to set aside orders and to permit limited discovery. We've talked about that a little bit, but again, essentially, that motion, if Your Honors review that motion in the record, it simply sought to relitigate matters that had already been adjudicated. That's not when a motion should be granted. The Winsler v. U case, although it's relied upon by plaintiff now and on appeal, and it was at the trial court level, was considered by the trial court. And I believe that's my time.
Thank you, counsel. We're here with the appellant rebuttal.
Thank you, Your Honors.
Let me start you off with a question so you don't have time to get into what you actually want to say.
Sounds good.
The Act is designed to challenge compliance with 121 via a motion to dismiss. If we say that anytime there's an issue with compliance with 121, you can discover the defendant's documents and see if they have them and see whether or not it's prejudiced, doesn't that defeat the whole point of requiring compliance and challenging it via 121? We have a discovery fishing expedition then anytime there's a prejudice issue.
Yes, Your Honor, and I think that goes to Judge Golden's catch-22 statement, as well as counsel referred to it as the paradigm of Martin, and we should probably refer to it more as the paradox of Martin, even though it's not all contained within Martin. In response, one of the issues and why we had a motion to amend the complaint was to bring in additional information, including the green slips. The green slips are not substantive like a certificate of compliance and are curable. And I'm going to slip that in there so I don't have to say it again. Also going forward, we were trying to get in that the documents, the only documents that the plaintiff received was from Erlanger, not from a separate PSYOX return from Dr. Shridharani. And that's all we can say. It's just a simple statement of counsel acting as a witness effectively in a case saying, that's the only records we got.
Couldn't you have included that as an allegation in the complaint?
And we can seek to amend that, Your Honor.
But the motion to amend, correct me if I'm wrong, motion to amend and the request for the discovery came after the motion to dismiss had been granted.
Forgive me for not recalling the timeline. I would probably agree with that. I think that was an attempt to try to make sure that we had a substantive enough record to bring up to the Court of Appeals so we wouldn't be sitting in here in this situation. And the alternative, why didn't you consider filing a motion to reconsider? Why didn't you consider filing a motion to amend? If these items aren't substantive, meaning fatal on the face of the complaint, like a certificate of compliance could be, then they could be corrected at a later date. And if we're allowed to go back, those could be easily corrected. Judge Davis, getting back to, I believe, finishing up your question, assuming I can get right back on track, is we do have this paradox. You have a Rule 56 hearing in which the defendants clearly brought in evidence outside of the complaint. Now we're seeking the same response to bring in evidence outside the complaint that the only records were received from Erlanger. They have a centralized system. It's well known. They took years and millions of dollars to create so that all the records could be there. So there's another fact. The other fact is we only received records from Erlanger and not from Dr. Shridharani. Now, how do we go about correcting that under this guise that we have a Rule 12 application, but evidence can't be provided or sought, even though effectively it's a Rule 56 argument? And that's where we have this issue, this paradox, this catch-22. If you do this, you can't do this. If you don't do this, you can't do this. It's just partially circular in its argument. And if you even look at Judge Kirby's concurring sort of opinion in Martin, she addresses the problems with the interpretations that 121 is bringing about so many absurd results. The court has said over the years, we do not want these procedural dismissals. We do not want a case to be determined before we can get the facts before the court. Yet 121, the more we look at this, the court has the consideration to make of, do we not permit this? And we have yet another absurd result, another reason to dismiss on 121. And there are plenty of reasons to dismiss on 121. Or
One might argue, though, that the easiest way to prevent or avoid all of these conundrums is to get the notice right to begin with.
Correct, Your Honor. I completely agree. And while I'm not conceding that the notice is incorrect at this point, there are so many technical aspects of it that it's almost considered not even malpractice to have these things have fault in these issues, despite the fact that given the fact that fault regularly occurs with these notices, be it from a pro se plaintiff to an attorney who has practiced and provided several 121 notices where you still have some sort of defect somewhere in that matter. So thank you, Your Honors. I appreciate your consideration of this case, and I appreciate your questions.
Court's thanks to both sides. I appreciate your briefs and your oral arguments on this. As it always is on cases involving the Health Care Liability Act, it's always interesting. You're excused.